Parties are ready. Mr. Valencia, you may begin.
Thank you, Madam Chief Justice. May it please the court, counsel. When a petitioner has been committed to a mental institution under state law, federal law restricts their firearm rights. Congress authorized states to grant relief from that federal firearm restriction in a very specific way. That authorization took form in Iowa Code Section 724.31. Last month, this court reasoned in Re N.F. that petitioners have both the burden of production and persuasion under that statute. Petitioners must establish a clean bill of current mental health to prove they are no longer dangerous. This case presents this court an opportunity to apply NS to ensure that petitioners are held to that burden. So we are here today because the district court erred as a matter of law when it granted petitioner NF relief. The court did not adequately consider or adequately assess each statutory factor because it failed to consider each of NF's mental health records, mental health diagnoses, and federal firearm prohibitors. Worse yet, the court erred because it granted that relief on a bare record. But before getting to the merits on the firearm restoration issue, I will first discuss why the state has a right to appeal in this case. Then I'll discuss the merits of the restoration issue. And third, I will discuss why this court does not need to consider the federal interpretive and constitutional issues petitioner raises for the first time on appeal. So turning to the issue whether the state has a right to appeal under 724.31. The right to appeal is purely statutory, and the state is granted the right to appeal under Iowa Rule of Appellate Procedure 6.103.
What is the role of the county attorney or the director in the district court proceeding?
Yes, Your Honor. So under 724.31, both the county attorney and the director are required to be served. So they both are entitled to present evidence in these cases. The county attorney here did not participate. Oftentimes they will participate. You'll recall that in the matter of AM, the county attorney supported the petition. In NS, excuse me, in NS, the county attorney opposed the petition, and here the county attorney just did not participate. The director...
They have a statutory right of participation. They can present evidence. They can cross-examine witnesses, but they're not parties, right?
No, Your Honor. They are parties to the case because under the statute, they're entitled to appear, object, and control the proceedings. And if we look at as how Iowa defines party, under 17A, or how Black's Law Dictionary defines party, it's somebody who is entitled to appear, entitled to marshal and control the proceedings, entitled to object and present evidence, and it's somebody who's been sued and brought into court. Just because the county attorney and the director have the option of whether to appear does not mean they're not parties. These proceedings are generally adversarial. Sometimes, though, the parties can come to an agreement that the relief may be granted. Here, the director chose to, under her right, to say, I'm going to object to this petition and oppose the petitioner. And if we look at, in the district court proceedings, in docket...
Sense that they would be subject to discovery?
The rules of discovery probably apply as well, so I suppose that there
historical information on how frequently a particular county attorney or the director opposes or doesn't oppose these petitions, would that be discoverable?
I'm not clear on whether that is something that has gone on before in these proceedings. I do know that parties generally engage in some bit of back and forth of discovery. For example, the county attorney or the director might request the mental health records from the petitioner that they are going to put into evidence at the hearing. But it is the petitioner who has to hand over those records under the burden of production. And the way that the parties were treated here in the district court, if you look at docket 6, if you look at the trial, at the hearing transcript, page 2, it's clear that even the district court referred to the director as a respondent. And a respondent is, the definition of a respondent is a party who is being sued and who can object to the proceedings. So these proceedings carried on throughout this case as the director as a party. There was never an objection raised below that the director wasn't a party or not entitled to participate.
Toronto, where your office is given authority to just appear and participate as a party. They don't have to show an injury, like something analogous to an Article 3 injury. And are you saying this is kind of the situation in these cases, that the director of Health and Human Services is statutorily designated a party, which the legislature has the authority to do.
Correct. And I think the director is a statutorily designated party because of what the director's duty and interest is. And in Chapter 217, the director's duty is to protect and improve the health and well-being and productivity of the people of the state of Iowa. So the director has an injury here if restoration relief is granted to somebody who has not sufficiently met the burden. That is the director's interest here. That is the director's injury here if that relief is granted. And because the director
granted in this case. I'm looking at subsection 5, requires immediate notification so that the petitioner can already exercise gun rights. Is that correct?
So, my apologies. The director here and the clerk and the DPS, my apologies, have complied with that provision. So my understanding is that his name has been removed so far, but this would be no different than when somebody sues for damages and then the winning party moves to collect on the damages and gets a payout. If the other party doesn't seek an appeal bond, if you win on appeal and reverse that, you can claw back your funds. Here, it's no different. Oftentimes, the director might move to stay and to stay the removal of the name. Those have often been denied. And so here, the director chose not to move for a stay. That doesn't mean, though, that if this court were to vacate the district court's order, then the initial underlying order from the Chapter 229 and Chapter 125 proceedings would then be back in effect. The effect of a district court order in these proceedings, these 724-31 restoration relief proceedings, is just to mean that the 229 proceeding is deemed to have not occurred. It doesn't wipe it away. So if you vacate the 724-31 order, then that goes back in effect and his name would have to be reported back to the database.
Somewhere, but have you ever come across a case by us or the Court of Appeals? This is very similar. The language is very similar to a juvenile section, 232.150, sealing of records. If somebody, after 2 years of being a juvenile and having records, if they want to have those things sealed, they have to give notice to everybody. It's more or less the same players. Do you know of any of those cases being appealed by the state upon the court's ruling?
With that particular section, Your Honor, I apologize. What I am familiar with, though, is the Chapter 229A proceedings for sexually violent predators. It also has very similar language to here. 229A.7 sub 5 says that if the court or jury determines that somebody is a sexually violent predator, then later in the paragraph it says the determination may be appealed.
It doesn't talk about appealing. So if it doesn't mention, I just wondered if you've considered, it's a very similar statute, how it plays out in your case.
Your Honor, I haven't considered the juvenile section you're raising, but I do think the 229A section is quite similar, and that this court dealt with that in Re Detention of Pierce in 2008. Very similar language where it says if the person here, it would be the petitioner seeking relief, but in that case it would be the person who's deemed a sexually violent predator, that the determination may be appealed, and it's linking it to the determination that they are a sexually violent predator. What this court said in Re Detention of Pierce is that even though there was, in that case, no express grant of authority in that statute for the state to appeal, the state was allowed to appeal because of 6.103, which also has the force and effect of a statute, and it was not expressly abrogated. And that's the same thing here. The state's right to appeal under 6.103 was not expressly abrogated, and so it has the right to appeal. But even if this court doesn't think that the state or the director is a party, that doesn't mean that the state can't appeal here. This court has often said that non-parties can seek cert, and that's what would be the case here. And that's especially okay when in the district court proceedings, the non-party seeking cert, their issues and their interests were already presented in the district court. That's exactly the case here. So if you find that the state's not a party, it does not mean that we couldn't then seek non-party cert, and then this court would review the district court's determination for illegality. We, of course, pressed the issue that we have a direct right to appeal in the statute. Our right to appeal under 6.103 has not been expressly abrogated. So this court generally does not impliedly remove the state's right to appeal. But if the state's not a party, we could seek non-party cert. And this court has done that often when the state hasn't appeared below. It's done that in Iowa Department of Transportation versus Iowa District Court for Lyon County in 1996 and other cases, because here the issues and the interests of the state were represented below. So turning to the merits of the 724-31 issue, The court here erred on two accounts. One, it erred as a matter of law because it didn't consider each and every one of the mental health records from petitioner NF, and it didn't consider each and every one of the mental health diagnoses. If you look at the district court's order, particularly the order denying the state's motion for reconsideration, the court carved out all substance abuse issues as effectively not mental health. That's not how Iowa treats substance abuse issues. They're called substance abuse disorders under Chapter 125.2 and Chapter 125, Sub 8 and Sub 16. The definition of a substance abuse disorder is a person who has a diagnosable substance use disorder of sufficient duration to meet diagnostic criteria specified within the most current Diagnostic and Statistical Manual of Mental Disorders. Substance use disorders are also mental health conditions.
If we agree with you, our review is de novo, so can we go ahead and review those records and still affirm if we believe that that's the right outcome?
Exactly right. If we have a right to appeal, the review would be de novo. If we were a non-party and we were seeking cert, of course, it would be corrections of errors at law. You could still review those documents because they should be part of the record. And those documents help show why the district court's determinations, its factual determinations, but also its determinations as a matter of law were incorrect. Those records are mental health records. They help show why NF was restricted. They help show under 724.31, the first prong, which is the original circumstances of committals. The Chapter 125 substance use committal was part of the original circumstances. The district court expressly said that has nothing to do here because it's not a mental health record. That is an error of law. The court said, I'm not considering this. I took judicial notice of it, but that doesn't absolve the error. It said those were not mental health records. That is incorrect.
If we agree with you, is the remedy to remand for a do-over, or do we decide based on the record on our de novo review?
We would ask you to decide and make this determination because the record is so clear. The record here shows, the swath of the record is this. The original committal proceedings in 2016, all the documents that went in there, including the diagnoses of various mental health professionals and the affidavits of NF's parents, and the clear and convincing finding of a court that NF had a serious mental impairment, substance use mental disorder, and posed a danger. That's in the record. What the district court left its decision on was what happened in 2023, which is NF's own testimony, which contradicted everything that happened in 2016, denied everything that happened in 2016. This court in NS said it won't believe a self-serving petitioner's testimony denying everything that happened in the original committal proceedings. That's this case.
Go ahead. Didn't the district court believe, though, and basically view the situation as one in which the petitioner was pretty open about what had happened at that time? Yeah, had a different viewpoint on what went, on some details, but had conceded quite a few things, had brought to bear facts that weren't present in the prior records, and overall found him credible.
That's correct. That is what the district court found. If this is de novo, you don't have to accept those credibility findings. Even if this is a correction of errors at law standard, the evidence doesn't support that finding. Because what the petitioner said is that not only did he just have a different view, he said, I was not violent. I never had a drinking issue. And all the 2016 proceedings, which were not appealed, by the way, all found by clear and convincing evidence that he did have all those issues. This court in NS said, we're not going to believe a statement that's self-serving in the moment to try to get their rights back when we have a very clear record that these issues did exist. One of the key things that's necessary for 724.31 relief is insight, accountability, and recognition of the issue and demonstrated.
Where are those things in the statute? I want to understand that, because we think of insight and accountability and these kind of things in terms of how somebody might recover from alcoholism or similar situation. Wasn't this more of a specific, like time-specific incident for this kid? Like he was 14 years old and 7 years have passed? It feels like two different kind of situations.
Point, we don't know if it was a time-specific situation because an absence of mental health records or episodes is not the evidence that they don't exist. But on your first point, where is that in the statute? The four prongs of subsection 3 read A, what are the original circumstances? And then D is, what are the change in petitioner's condition or circumstances? And so what we look at here is the original circumstances were that the petitioner here denied everything in 2016. If I may finish my answer here. In 2016, the petitioner denied everything that was happening, said it was his mom that was making this all up, denied that he had any issue in 2016. He's saying the same things now. There is no change in condition or in circumstances. The condition remains the same. The issue that occurred in 2016, which was drinking and those sort of things, still occurs now, just as it did in NS, where the substance being abused in the original committal proceedings was still being abused at the time of seeking relief. Thank you.
Thank you, Chief Justice, and may it please the court. I want to take a step back. We're here today talking about the collateral consequences imposed on a 14-year-old who was briefly committed, and those commitment cases were just...
Even though I did 1 million commitments, even though it ended up not really reaching fruition, there was a period of time where he was under court direction and actually within the grasp of the court system, correct?
time. And
Time requirement in our statute, what qualifies as being committed?
no, but the big picture here is a brief period in this young man's life in which he was subject to a court order. And then later, no professional can ever produce to court a report that complies with the law to sustain any of the allegations. And the juvenile court dismisses all of the commitment proceedings that are against him.
That happens sometimes when you do a commitment and it looks good on paper, and I'm not going to be the person that denies it and come to find out there really was a danger and they hurt themselves or others or whatever. So sometimes it's not the greatest evidence, but it's enough to make me sign that first order. And then you send them off and they have all their evaluations and testing and it comes back, not such a strong case, and I would dismiss it. But they were committed for that period of time, weren't they?
I'm not denying that this young man was committed. But the big picture point of here today, the director fights bitterly to preserve the collateral consequences on him years later, when what happened was a brief commitment, and perhaps juvenile court judges do that prophylactically. The statute...
District court too, big people too. It happens, everyone.
I'll step away from that adjective, but maybe it's done prophylactically. Now, the code doesn't say, when in doubt, commit people. I'll point that out. And the reality is no professional ever produced a report that sustained any of the allegations. And the director's brief is replete with unlicensed psychoanalysis of this young man based on insight or what the director thinks really should be an adequate showing for him to get his rights back. Well, what we have here is an experienced district court judge who got to see him and hear from him and realize that this incident is a brief, acute episode in which this young man's home life fell apart. And thankfully, he got into a better home life with a foster parent in the community who stepped up and gave him all the stability he needs and is making him the productive young adult he is today. Now,
Requirement in the statute that an applicant must get a fresh mental health examination? Could the county attorney request an independent medical evaluation?
this court has not heard a case where the parties have litigated that. The way the statute reads is that the court must consider, at a minimum, the petitioner's mental health records and criminal history records, if any. Now, the court had some mental health records, but there's nothing in the code that requires a quote-unquote fresh evaluation of the individual.
Shows that your client produced evidence to say I've been good, there's been no problems, and that there would not maybe be a need for another evaluation?
I believe that, and Judge Neary believed that he had demonstrated that this was an acute aberration in his life and that he has not needed mental health treatment. And there's never been a document introduced in the record by a qualified professional that says, yes, he has a persistent mental health condition. He got committed by his parents in the middle of a crisis, and then later produced evidence that that crisis was probably likely caused by his drug-addicted mother, not him.
That's his own testimony.
Judge Neary credited in his findings about his mother's struggles during that time period and what caused that there. So the legislature easily could have said that a petitioner has to file a mental health evaluation within the last 6 months or something like that. It didn't do that. It provided an escape valve with the extraordinarily harsh result of a commitment that somebody carries with them for the rest of their life.
I know in the prior case, there's some of us who think that under the new constitutional amendment, the ultimate burden of persuasion switches to the state. But the statute is written with the burden of persuasion on the petitioner. And so if you follow the statute, the petitioner might normally have to bring in a mental evaluation. But then if you evaluate it as at least some of us and to be determined later think the matter has to be evaluated under the constitutional amendment, now there's a burden of production on the petitioner. So, what do we do with that? I am troubled that he declined this mental evaluation.
NS had been submitted after NF, and uncomfortably watched that oral argument in my office screaming at the screen because I don't think that case was presented in the same way that this one is, that they hung their hat on Section 1, Article 1, Section 1A, which we've not raised. And for all the reasons cited, in the footnote 5 in NS is why I didn't raise any Iowa constitutional claims. The statute, I think, makes you a petitioner. That implies that you have to do something to get into court, and we've not made any state constitutional law claims about this because the same legislature that passed this is the one that sent the gun rights amendment to the voters, and if they wanted to change this because they thought the gun rights amendment and this conflicted.
That argument, Mr. Ostergren, that's strict scrutiny is a defined term in the law, in constitutional law, and those statutes are out there, and I don't think the legislature, I don't think you can square all of them necessarily with strict scrutiny, but I'm just one.
And I'm representing this young man on appeal. I didn't have the opportunity to represent him in the district court, and so we're making the record that I thought was best made here. Other things that aren't in the brief, though, that you helped my friend was suggesting quo warranto. The director never argued that this is analogous to a quo warranto. Those arguments were not made in the director's brief. And
because if the statute makes the director of Health and Human Services a party below, the Attorney General is capable of representing them below and on appeal, and that seems enough to take care of all the standing issues.
be clear, whether there are parties only half the battle. The statute specifically says a petitioner who's denied relief can appeal. And the specific provision of a right to appeal implies that the director and the county attorney lack a right of appeal.
This is logical, that the federal legislation that 72431 is intended to encapsulate specifically required the state to provide an avenue for appeal and that it had to be de novo. And 72431.4 seems to follow that language pretty clearly. So couldn't we just read that as the General Assembly was making sure that they were following the federal legislation when they were enacting 724 and that they were not intending to say that the state could not also appeal?
Those two things are inconsistent, Your Honor. I agree that 724.31 is written with a mind toward complying with the 2007 NICS Act and making the state eligible for the federal funds that flow if you have a statute like 724.31. That's obviously true. But I would say if they had enacted word for word what the federal statute says, the federal statute, the NICS Act, says that the state's appeal process must permit a person whose application for the relief is denied to file a petition with the state court of appropriate jurisdiction, yada, yada, yada. So I don't think there's necessarily an inconsistency there, but the language that the legislature chose is the petitioner may appeal a denial of the requested relief. It's, you know, my friend cited the in-rate detention of Pierce case, and of course I don't have the cite to the Northwestern Reporter handy because that's not in the director's brief either. They've not preserved that argument that somehow this language preserves for the director this appeal right.
Case. I mean, it strikes me as really strange that the state wouldn't have a right to appeal this in a civil case. Are there other examples where in civil cases the state can't appeal?
None come to mind. But I would tell you that this is not a normal civil case. This is somebody asking to have their rights restored.
Court had said, I don't believe that anyone's gun rights should be taken away. I don't care what your mental health record said, I'm going to restore yours. The state wouldn't be able to appeal that?
Language here, no. I want to quibble with the language. Would the director be able to? No. Okay. Now, could that order implicate some sort of interest of another constitutional officer? I think that analysis would have to be made. But I very deliberately filed a motion to dismiss the appeal in order to make the director put her cards on the table in the opening brief. And the director's argument here doesn't make that claim. It doesn't deal with that eventuality. We'd litigate that case if a district court judge says that. But the director, by statute, doesn't have an express grant of appeal. The rules cannot fill in that gap when the statute gives the right to one party but not to somebody else. And I'm sorry. And the argument that somehow we could be here on a certiorari petition, I think, runs squarely into the Crowell versus State Public Defender case. The director has not been injured by the grant of this relief. And the way this works is when the judge enters the order, the clerk clicks something in the computer system and that data goes automatically through. The director of Health and Human Services did not have to lift a finger in response to this order. The director of HHS has not been harmed here and so has no right to be in court unless this court is going to throw out all the rules on standing for certiorari petitions. The director has not been harmed by this order. Now, whether in your example, Justice Oxley, of a district court judge just ignoring what the law says and going out, guns blazing, no pun intended, we'd have to figure out if there's a different government official who would be injured by that, who could raise the interests of the state of Iowa or their own interest as an officer to challenge that. But what's clear is the director doesn't have that kind of interest here, and so the appeal should be dismissed.
By implication from the statute, giving the petitioner the right, but not the director.
Right, but I mean, that's, you know, I suppose you can always think of a way it could be more clear. You can always imagine language where you would more clearly win. But the legislature said the petitioner has a right to appeal, as opposed to saying, like in what my friend cited from the sexually violent predator statute, the determination may be appealed. That's a much more general language that focuses on the court's order could be appealed, as opposed to the individual who can invoke appellate jurisdiction.
I'm still confused. If they're a party below, and I tend to agree with you that it would be odd to say the petitioner has a right to appeal and to mean that the state also has a right to appeal. If they're a party below and they lose, why can't they seek certiorari review?
Well, you would have, taking that argument, which is not exactly what my friend argued in the brief, okay? So I'm gonna jump in. Had that been made, this is what I would have responded. The court would have to reverse, I think, your decision in Dickey versus Public Information Board, where it distinguished being a party in a 17A proceeding and your ability to appeal to the Supreme Court.
No, because Dickey was an administrative proceeding, and it was whether you can take go from an administrative proceeding to district court. Here, we're going whether you can go from district court up to this court. It's entirely different.
In that, the district court in a 17A is exercising an appellate function in the first course and then subject to review by this court. But
A standing is defined in the statute as you have to show that you're adversely affected in order to get into court.
I don't think that's what 17A says as to the definition of a party, that you're interested in it, not you're adversely affected by it. So had my friend made this argument, right,
Lawyer, but I know my own case.
if you could make sure you're speaking to the microphone.
The director is a party below?
I think not. I think it's not necessary for the court to determine that the director is not a party because of how the appellate right is defined. But I may continue answering Justice Waterman's question, Your Honor. Thank you. I don't think so, because you have this incongruous situation of then you have two government officials, the county attorney and the director, who are each entitled to come into court. Who's speaking for the state of Iowa there if they're coming in representing some other broader interest? I think they got notice and they have an opportunity to give input, and it's ultimately up to the district court to decide if the statute has been satisfied. I would ask the court to affirm the district court. Thank you.
Mr. Valencia?
Thank you, Your Honor. The legislature knows how to limit the state's right to appeal. It's done that in many other circumstances. It's done that in 6.103 for small claims actions, does that for interlocutory orders, and it's done that quite clearly for criminal cases in Chapter 814. Nowhere here can we point to a statute that says that limits the state's right to appeal. They're simply just pointing to a statute that confirms that the petitioner has the right to appeal. The legislature omitted the word only the petitioner may appeal. It did not expressly abrogate the state's right to appeal. The Crowell case that my friend on the other side mentions is interesting because it's an attorney's fees case. Attorney's fees, this court determined the public defender there didn't have a injury because the public defender was not the one who'd be paying out the funds. The Department of Management was. So the court allowed the Department of Management to appeal there via cert, even though the Department of Management, I don't think, was a party there. So that's an interesting case that supports allowing this. Sorry.
In the pre-NICS world, the restoration of rights was performed through Attorney General review, correct?
Attorney General review, correct.
In that scheme, there was no need for the government to appeal because the decision was at the discretion of the Attorney General. Only the petitioner would need the right to appeal, right? I mean, the Attorney General wouldn't appeal his own decision or her own decision.
The pre-NICS world, the Attorney General would only grant relief upon a finding of the petitioner not being in danger any longer, which is what's missing here.
My only thought here is if you're kind of replicating that scheme in some way at the state level, and the statute directs the proceeding to be in front of the district court from which the disability arises, if the district court is satisfied, the one that's causing the disability, that this person no longer poses a threat and restoration of rights is in the interest of the public or not detrimental to the interest of the public, then why isn't that enough, right? So you have the person or the court that's causing the disability making a determination. So why does the state need a right?
Because as my friend on the other side admits, it would be a unique circumstance where the state's a civil party and is not able to appeal. And you can imagine a case here where a district court sort of goes rogue and there's no evidentiary, evidence at all, even though we have thin evidence here, there's at least testimony, and still grants the relief. The legislature here has found that the Department of Health and Human Services has an interest in protecting the safety of Iowans. That's the interest here. That's the interest that's harmed if somebody gets relief without making the proper evidentiary showing that this court required in NS, which is to produce evidence and persuade the court that the petitioner at the time of filing has a clean bill of current mental health.
So we noted that the kind of mental health evaluation arranged by petitioner's lawyer close in time raised a bunch of red flags, and we found on our de novo review it was not a clean bill of mental health. But here, we don't have that, and if your concern is the absence of a new mental health evaluation, why didn't the director or county attorney request one through a court order for an independent medical exam under our Iowa Rules of Civil Procedure?
There's precise thinking here, but what I can say is that it's the petitioner's burden to put the right evidence in the record. And the evidence here did not show, clarify one point. I'm not saying that a current evaluation at the time of a filing of a 724-31 petition is required. The statute does not require that. What it requires is you show a change in your mental health circumstances. What the evidence here shows is the same circumstances of the petitioner denying there was any issue in 2016 and confirming that he still denies today that there's any issue. And so there's...
Let me ask you, I want to back up and ask you about something you raised in your original argument, Mr. Valencia. So I looked over again the 1904 ruling by Judge Neary, because one of the points you're making is you're not just asking us to reevaluate the facts as seen by the judge who saw the petitioner, but you said he made a legal error because he disregarded the substance abuse stuff. Looking at page 3, after he's made what you consider to be the legal error, he says, despite this lengthy discussion, the court nevertheless considered the information it had at its disposal at the trial and concluded as it did, irrespective of the arguments of DHS, the court, despite assertions to the contrary, did not refuse to consider the substance-related information nor fail to give it proper consideration. So what do you make of that? He's sort of saying, in the alternative, I did consider it, and it wouldn't have changed my decision.
May answer the question. He's not, what he's saying, yes, is that in the alternative, I'm considering it. He did not say that in the alternative, I'm considering it as a mental health record, a mental health diagnosis, or as a federal firearm prohibitor. Those are the errors of law. So just because he considered this evidence, the statute only requires you to consider mental health records, if any. So he says those are there, they're not mental health records. But here they confirm the existence of the issues. So if you look at the underlying substance use committal proceeding, docket 12, at that time when the proceeding was dismissed for a technicality, the medical professional there, MD, said his prognosis is poor, he's not investing in himself, he's not admitting to these things. That's in the Chapter 125 proceeding record. If you don't consider that a mental health record, then it's not factoring into the 724-31 analysis properly. Thank you, Your Honor.
Could I have, I'm sorry.
Let me clarify, I can't hear out of my right ear, so I looked and I didn't see you talking, and so it's a game sometimes. I was not being rude, I'm sorry. Yeah.
I just wanted to clarify one thing, and conceding that the petitioner does have the burden in these situations, but I see that in the record there's an exhibit where the Department of Health and Human Services sent a letter to the petitioner and had him fill out various answers to questions and then ask for some specific documents. And as I read it, what they wanted was, please obtain any mental health records for the last 5 years and forward to us. And if he has no mental health records, I guess he wouldn't have anything to send, right? And I don't see any question here about that. If you don't have mental health records, go out and spend whatever it takes to get an eval. Am I reading that correctly?
Document says. The document also includes his responses saying, I was never violent, I don't recall being violent, I didn't have a drinking problem. The director is not going to tell him how to run his case. It was his burden if he wanted to make the showing. He didn't. And that's one of the important considerations here is you can refile every 2 years. He filed in August 2023. He could refile August 2025. Now that he knows, like the court said the district court said at the end of the transcript for this hearing, hey, if you don't win your case, I would recommend you go get an eval contemporaneous with your filing and refile. So he has the right to refile. In those documents, those are actually interesting because they confirm that he's still denying everything. And one more point, yes, there aren't mental health records, but it would be quite the incentive for this court to say, if you just don't say I have any records, we don't, as a state, we don't know who to subpoena, we don't know where to get your records. That's why this court in NS put the burden on the petitioners, because the petitioner is the one who is aware of their documents. And then to assess the credibility of that person, we just look to see, okay, well, you can imagine a situation, somebody comes in, 10 years, law-abiding, says I don't have any issues, and they're credible because they say, I had these issues 10 years ago. I addressed them myself. I didn't want to see a therapist. I had these issues, and I've changed. Here he says, I didn't change because I'm exactly the same as I was in 2016, and I'm effectively trying to just overturn the 2016 finding.
The court to decide whether he was credible or not.
Was the district court's determination, and under de novo review, this court could make its own, and also on corrections of errors of law, it still needs to be supported by evidence, and it's not here. Thank you, Your Honor.
In the interest of NF is hereby submitted, and court is adjourned for the morning. Thank you.